This is the Getting Divorced Without Losing Your Mind podcast, where divorce coach Corey Shapiro helps you get creative and not reactive in your divorce. Tune in now and get the support you need to make it through this difficult time. Here's Corey Shapiro.
Welcome, it's Corey, your friendly divorce coach, helping you get divorced without losing your mind. It's true, it's possible to get a divorce without losing your mind. And I'm here to help you discover how to do that. How can I help you? By providing you with divorce coaching. Because divorce can feel like a fire. There are flames everywhere. And you are just not sure which way to turn without getting burned. But if we look at it differently, it should not necessarily be about fighting the fire, but preventing the fire in the first place. Some people feel like they are getting burned by having the wrong divorce attorney. So in today's podcast, we are going to discuss what to consider when you are thinking about changing counsel. But first, it's time for the quote of the week. You know, I recently quoted a former president, Abraham Lincoln. Today, we are going a little bit more modern. I want to hear from the wisdom of Wiz Khalifa, the rapper. His wisdom is never make permanent decisions on temporary feelings. Thanks, Wiz. I think that advice is excellent. It's excellent because if we're in that moment, we don't necessarily think about second order consequences. What could happen? How can this be reframed by the other side? What are the impact of our decisions long term? So I want you to think about that. Let's talk about something in the divorce world. Let's say you request sole custody and primary residential custody, even though the other parent is fit. And you're in a jurisdiction that has a preference for 50-50. 50-50 is equal parenting time. So if the other parent's fit and you're in a jurisdiction that has a preference for 50-50, and that parent may not be as good as you, may not be as involved as you, may not be as active as you, that doesn't necessarily mean you get sole custody. Maybe in those jurisdictions, they're looking to give sole custody only if the other parent is unfit. And by making that decision early on, which usually happens in a pleading, that initial document that's sent to the other side, it could be a summons or a lawyer letter. And then that colors everything, and it makes it very challenging to resolve not only the parenting issues, but the divorce. Also hard to co-parent effectively in the future. And if you get a certain type of an attorney, they may even use the fact that you're making these requests, this request for sole custody, even though the other parent is not necessarily unfit, just not necessarily as good as you, that now you're alienating, you're interfering with the child and the child's relationship with the other parent. And such interference is so against the best interest of the children that the other parent, who's not even as good as you, not as involved as you, not the emotional, psychological, active parent, not the one who goes to doctor's appointments, dentist appointments, activities, knows the teachers, everything, that parent may actually get custody. So that's what we're dealing with. So thanks, Wiz, for that wisdom. All right, let's get started with the question of the week. If you have a question you would like answered for the podcast, please go to question.gettingdivorced.org. And I may answer your question on an upcoming episode of the Getting Divorced Without Losing Your Mind podcast. This week's question is from Jennifer. Jennifer asks, I'm currently in the middle of a custody battle, and I'm looking for a second opinion. My lawyer is great, but I'm not sure if they have the specific knowledge about high conflict individuals that I need. What should I be looking for if I decide to change divorce attorneys? Well, Jennifer, I feel for you. If you're in a high conflict divorce, that's a fire. And it's hard because every turn you make, it does feel like you're going to get burned. It's like I heard recently this saying, it's like pulling a tooth from an alligator. It's a difficult proposition. Let me give you some perspective on this. And I like to think of attorneys, divorce attorneys in particular, as having two main skill sets. And I'm not sure if your attorney has either of them, but if they are great, you think they're great, they may have the first one. They may also have the second one too. The first one is being a counselor, being an advisor, a trusted advisor. The second one is being an advocate. Let's talk first about being a counselor. Counselors are looking to cooperate. They're looking for a win-win. They provide documents when requested. They send semi-reasonable, not fantasy type of requests for settlement positions or proposals. They will agree to maintain the status quo. They're not going to do anything crazy. They're not going to take you off of health insurance. They're just trying to be cooperative, not get anyone too defensive, too nervous, too scared, and try to work things out in a diplomatic way, bringing in professionals such as a mediator, a parenting coordinator, a child specialist. These types of people are used to help people work through difficult situations. That's the no court counselor approach. The other approach is when you have to be an advocate, and that's when you go to court. That's what we call litigation, going to court. And being a litigator, being an advocate is a different context. Now, you may hear some attorneys talk about litigation light. And litigation light is really using the court system just a little bit, just to push the other side, a little bit. And if you're dealing with semi-reasonable people who have a budget, and you go to court that first time and the judge looks very opposing, and the judge gives some recommendations, some directions, that's litigation light, and most people are going to follow it. So, for example, you go to court, I want sole custody. The court says not going to happen in my jurisdiction unless the other parent's unfit. Is the other parent unfit? No, they're not. Well, in this jurisdiction, we do 50-50 or meaningful time. Talk to your attorney, come back in 30, 60 days. And then if you're able to change your position because now you heard from the judge where the buck stops, then that's litigation light. But sometimes you're in a real litigation that could last for years where the other side's out for blood. And they are serious position polarization. And in that case, you're not just playing chess. You're playing 3D chess. And why I call it 3D chess is because you are creating a frame, a story that appears true, but is not necessarily the truth. It's just based on a story. You might have seen it in popular media with the O.J. Simpson case or more recently with Johnny Depp. We don't really know what happened, but there's these strong frames and really high-level advocates know human psychology and know how to make what looks like a bully, become a victim. And that's why it's 3D chess. And in that case, that's a different skill set from a counselor. So you have a counselor skill set and an advocate skill set. Now, if we're going to call it different terms, we can call it someone who's versed in the handshake method versus someone who is versed in the hand grenade method. Now, there are attorneys who can do both. They can be collaborative, they could be great counselors, and they can also do, let's call it the rough stuff, being strong advocates. And they don't really want to be rough necessarily, but they will do what's necessary to protect their clients. So if you are thinking about changing counsel, Jennifer, it's a simple process. All you need to do is consult with other attorneys. And in most jurisdictions, assuming you can pay for this new attorney, assuming you paid for your previous attorney, you can just sign a simple form and get a new attorney. I will say, though, that just because you have a new attorney doesn't necessarily mean you're going to achieve your goals. A lot of attorneys are also good salespeople. And if you have a position that is really just a fantasy, there is a potential to get what you want. It's a low, it's a low percentage, could be 25, 10, 15%. But at least getting a second opinion, you can get a feel, and hopefully you'll get a trusted advisor who will tell you if your position is reasonable or not. Hope that's helpful for you. All right, in divorce news, let's switch gears and let's talk about this husband who tries to deceive a court. He tries to deceive a court. You heard me right. And yes, people try to deceive the court. What? Because when I go to court, I try to tell the truth, nothing but the truth. That's what I do. But other people have a different way of doing things. And here's a great example of what you're going to find when someone has lost their mind. I'm going to change the names and I'm going to call them Sally and Greg. And Sally and Greg got married in 2002. They had a child in 2006. Divorce action started in 2014. 2015, they settled. Greg got custody of the child. That sounds so far so good. But here's where things went south. When you settle, you enter into these marital settlement agreements, these separation agreements, these parenting plans, when everything's resolved, written form. A lot of times, some jurisdictions require you to go to court, or maybe the attorneys want you to, and you do what's called an allocution, where you go to court and the judge basically asks you some very standard questions to make sure that you're not being forced to enter into the agreement, that you're satisfied with your attorney, and they just want to make sure everything's okay. Everything's above board. And if you have any questions for the court, a lot of times it's perfunctory. And at that point, you just say yes. And the judge says at the end, okay, fair enough. After doing the allocution, they give you 60 days. Every jurisdiction might be a little different. They give you some time, more than a reasonable amount of time, to submit every document you need. And to submit documents for the divorce at that time, we're talking procedural. We're talking paralegal type work. Very simple stuff. You don't need a brain surgeon type of an attorney to do this. It's just procedural. All the hard stuff's over. It's just processing papers. Few hours of work. Few documents need to be signed. But in this case, between Sally and Greg, it turned into a little bit of a nightmare because it never was done. Yep, no, it wasn't done in 2015, wasn't done within 60 days, wasn't done in 2016, wasn't done in 2017. But in 2018, there was an issue between them where Sally accused Greg of neglecting the child in family court. Divorces are usually in Supreme Court, a different court. The family court granted that. Custody was changed in family court in 2018. And I guess Greg, being upset, moved forward with the divorce maybe a year or two later and never told that court anything about what happened in family court and just based the divorce judgment on the 2015 agreement that gave him custody of the child. Now, at this point, Sally moved to a different state. She's living her life. She just wants a divorce based on the real terms, which is what happened also in 2018 that modified the agreement. And Greg just couldn't let go. And he hired what I'm going to call an attorney for hire. They just do what you want to do, even if it's fantasy world. And literally submitted an affidavit to the court, and all these papers to the court, omitting anything about the family court, the 2018 change in custody. And when Sally got a hold of this, hired this attorney in New York and basically told the court what's going on, that this guy is committing a fraud on the court. Yes, a fraud on the court. And when the court realized what happened, it immediately changed the judgment of divorce and awarded attorney fees for the other side. I think in the amount of about $18,000. But this attorney didn't stop there. The attorney, let me just make sure we're clear. The attorney who represented Sally, the white knight in this situation, the one who's protecting the spouse or the former spouse from this deceit. Greg attorney was the one that did this deceit. So Sally's attorney, this good guy, he also realized, well, we can not only get our attorney's fees back, but because of the nature of the deceit and because of the attorney involvement, there's a little known law in New York where we can move for what's called treble damages. Treble damages. That just means triple the damages. So it's not only $18,000 we get back, but around $54,000. And that's what Sally got. $54,000 because of this fraud, this deceit, because Greg lost his mind. All right. You know, I like to end on a positive note. So it's time for positive perspective. I know that was a little heavy divorce news, but I wanted to give you an example of what could happen when you're in this high conflict situation where someone has lost their mind. And the positive perspective is you need to have a trusted advisor like that attorney in that case. Sally had Elliot Poland, a respected attorney here in New York who is versed in not only the handshake method, but also the hand grenade method, and can do the rough stuff when necessary to stand his ground to protect his client's interests. I will read the words of another respected attorney who many consider to be a trusted advisor who makes this point clear. She said, her name is Pamela Sloan here in New York, Pamela Sloan, and many people go to her as a trusted advisor. She says on her website, she believes bombastic and ill-mannered lawyering does not equate to tough lawyering. How true is that? That's like the barking dog. Barking dogs are not necessarily tough. Her experience shows those behaviors most often result in unnecessary emotional and financial costs to the client because everyone's getting defensive, everyone's escalating. She believes the best results for a client come from knowing the facts. It's really getting deep, rolling up your sleeves, and the law, understanding reality, and listening to and understanding the opposing side's position. What's really going on? And it's not usually about what you think it's going on. It's not usually about the position. It's like an iceberg. What's underneath that's driving this? And looking for reasonable compromises and when necessary, just like Elliot Poland, standing her and her client's ground in both negotiation, that's the handshake, and litigation, that's the hand grenade where you need to sometimes do the rough stuff if someone like Greg from Divorce News has lost their mind. That's a wrap on this episode. I'm so glad you're taking a creative and proactive approach to your divorce. Keep up the good work and remember to stay focused on yourself and the things that you can control. You can do this. You're not alone. You got me helping you get divorced without losing your mind.
Thank you for tuning in to the Getting Divorced Without Losing Your Mind podcast with divorce coach Corey Shapiro. Divorce can be a difficult and overwhelming process, but it doesn't have to be. Corey's book is here to help you gain clarity, composure, and a strategic mindset. Get it now as an ebook on Amazon or an audiobook on Audible and unlock the power of these resources to make more informed decisions and gain a better understanding of the process.
This podcast offers general information only. It cannot replace legal advice. If you need tailored advice, contact an attorney licensed to practice in your area.